Thank you, Joel and Zaina. I'm going to talk about medical legal issues. How do I advance this?
Hold on a second. Just have to this here. Where is it? Off. Here. Keep the cursor here.
All right. Okay, these disclosures are not relevant. So what do laser surgeons get sued for? Most commonly, hair removal, which is the most common laser procedure performed. Rejuvenation, which is mostly IPL. The most common injuries are burns, scars, and pigmentation, and the most common reason for getting sued is medical malpractice. 50% of the decisions go in favor of the plaintiff, 50% in favor of the defendant. In our study in JAMA Dermatology, there were judgments that went from $5,000 to $2.145 million. The top judgments were for wrongful death. They had nothing to do with lasers. They had to do with excessive anesthesia, topical anesthesia being applied to the patient that resulted in their death. In terms of risk factors for litigation in dermatology, I know only a fraction of the site are dermatology. The incidence is low, but cosmetic procedures are the #1 reason. The top risk factors are male gender and practicing in a solo practice, and that is being published in the next month. It's available online. So non-physician litigation data, we saw trend lines beginning in 2008. Where the proportion of cases began to increase. Over a period of 2008 to 2012, it went from 36% of cases to about 78% of cases, and we reported that in JAMA Dermatology as well in 2014. 23.4% of these cases arose in medical offices, 76.6% arose in non-traditional areas such as medi-spas. And then we did this paper again, looked at the same data in 2022, and the proportion was still 2 to 1. About 66% of cases involving non-physicians were performed in medi-spas, and about 34% were in medical office settings. So it seems that the location and potentially the supervision are issues that are important to patient safety. And if you look in terms of who governs laser delegation, the state laws vary widely. And this was actually the most cited article in LSM in 2018. These are the state laws that vary state to state in the entire country. And depending on where you practice, if you practice in the United States, they may vary greatly, and it's incumbent upon you to know that. So what is malpractice? Well, this is a whole course in law school on torts. I'm going to do it in 2-3 slides. It's breach of a duty that causes harm. And the standard of that is that of a reasonable duty, the quality of care at a level consonant with medical knowledge and judgment that a physician is reasonably expected to possess, and is a duty based upon the adept use of such medical facilities, services, and equipment that are available to the physician. Now, litigating that standard is done by expert testimony, medical literature, standard practice, and clinical guidelines. In terms of expert witnesses, they're the ones who kind of set the standard. The standard isn't very high. It's up to the trial judge. They don't need to be in your specialty. They don't even need board certification. It's a very wide ranging standard there. And basically, the plaintiff has to show that there is a standard of care and that the physician or practitioner failed to meet that standard to a reasonable degree of medical and scientific certainty. Now, we've all heard about statute of limitations, and that's usually 2 to 3 years after the injury of malpractice. But the key here is the timing. It's when the plaintiff suffers the injury or when they should become reasonably aware of when they suffered the injury. So this is delayed hypopigmentation after CO2. Joel showed some great slides on that. That doesn't appear for 6 months, so the statute moves along with that. If it's recurrence or metastasis of a squamous cell, let's say years after excision, that's not a laser thing, but just for the concept, that might be years later. The statute of limitations doesn't start until the patient should have become aware of that, which would be an appointment at a physician's office. Doctrine of informed consent. This is completely distinct. If you take nothing else out of this talk, malpractice and consent have nothing to do with each other. Consent is getting permission to do a procedure. You need it actually for any medical intervention that you perform. And what you need to do is to provide information to enable the patient or guardian to choose knowledgeably among reasonable medical alternatives. This places the patient in control of the course of their medical treatment. So you need to discuss the diagnosis, the medical steps preceding the diagnosis, the nature and purpose of treatment, the risks and alternatives of the procedure, particularly if they're high risks. Failure to obtain an informed consent constitutes a battery. This is a civil battery, and the physician is liable for civil damages. Now, what do you need to show to get an action informed consent? The course of treatment carried an undisclosed risk. You didn't tell the patient. The non-disclosure of that risk breached the applicable standard of care that caused the undisclosed risk caused the patient injury, and with proper disclosure, patient would have made a different treatment choice. Patient need only show that he or she was not informed of the very nature of the medical touching. Physical injury here is not necessary. Now, you're not going to get a great judgment if there's no harm, but theoretically, you don't need to show it. An example of things that can be batteries that you'd never think about are extending a procedure beyond the area of which the patient is aware, including, let's say you extend a liposuction to areas that are not involved, or do a laser procedure and you decide to do the neck, just, as kind of just helping the patient out. Those are considered a battery if something goes wrong, and it's easier to prove the negligence and it favors the plaintiff. It does not require standard of care or an expert witness, need only show non-consensual touching. So when you do consent, it's really important to keep your consent simple. The whole idea is that the patient understands what the risks and benefits are. You don't want to use medical jargon, and I always include the fact that the FDA status may not have been established, because much of what we do is not approved by the FDA. This is just a little translation of medical terms to layperson terms. You want to use the term blisters, not bulli, for example. And blanket authorizations, you can't hold me liable for anything. Courts disfavor them. They need more specificity because it isn't an informed consent, so those are not valid. Physician extenders, this is an important concept. This is respondeat superior. This is the physician is held liable for a physician extender's negligence, provided he or she is an employee receiving a salary, benefits, and performing within the scope of his or her duty, regardless if the patient saw the patient or not at that visit. And again, supervision of non-physician laser procedures varies state to state. Some jurisdictions require on-site supervision by physicians, others do not. So the take-home point here is to provide excellent training and appropriate supervision, and if you're the owner of that practice, you are liable in the event of negligence, even though you never was part of the treatment, were part of the treatment. So to conclude, malpractice and informed consent are distinct legal doctrines. The physician-patient relationship is the key factor preventing litigation. Have a good relationship with your patient. There has been a dramatic rise in the incidence of litigation against non-physician laser operators, and the physician employer is liable for injuries caused by the non-physician. Thank you.